Hey, Peter there. Once again, I welcome you to these video lecture snapshots. As you know, right now, all over the world, we are required to work from home. And this is the best I can do to share with you all that I can to help us to understand the administrative law and its nature from the academic perspective. I would like today to talk about the theoretical framework, the theoretical approach that we give to the administrative law as we know it. I would like to rely on two fundamental theories. The first one, I would refer to a scholar, David Henry Rosenblum, born in 1943. Second, I would refer to Paul Phillips Craig, a law scholar, a law professor, hailing from the United Kingdom and born back in 1951. Both seem to be contemporaries and well known for their expertise in public administration issues and as well as policies, public policies, decision making in the public administration, and they are going to enrich our thinking about public administration law in the Republic of Kenya. Back to our reality, as I said at the beginning, the previous videos, law is very contextualized. And in this case, we take Kenya as the context in which we want to look at the development of administrative law. Going back to the Constitution of the Republic of Kenya of 2010, under Article 47, Fair Administrative Action as one of the fundamental rights of the citizens of Kenya. The right to access fair administrative action is explained by the law under being expeditious, being efficient, and being reasonable, and last but not the least, procedurally fair. All these things said together, expeditious goes with the rapidity of accessing justice and accessing administrative action. And this is by the Constitution, and it is a right. Going back to our theoretical framework, looking at the approach of David Rosenblum, he gives us the three approaches. The first approach is managerial. Second approach is political. Third approach is legal. In the first approach, managerial, the public administration must perform managerial actions and must be in charge of various organizations within the government. And the public administration must ensure that organizations in terms of agencies, government agencies, small units, departments, act according to the law, act within the profession, and using the technical procedures to carry out their duties without failure. By doing so, it doesn't exclude also offering leadership, offering the supervision, and offering the follow-up and the liability. The approach number two on political aspect, Rosenblum tends to give more value to the legislators. And in this case, the politicians are the last decision when it comes to the issuance of law or enactment of law, the revocation or the repeal of a particular law, and replacing that law with a new law. And this one, again, is anchored on the public policies that have been found to be working and pushed by the executive to the level of the bill. Now, such kinds of public bills that come from the executive can enjoy also the accordance of credibility by the legislators that will legislate over it, pass it through the parliamentarian committees for further evaluation and technical addition and more information and participation from the public. Then it is brought back to the floor of the House for reading, debating, and finally at the end, if passed, then it becomes the Bill of Parliament. Now, by doing this, Rosenblum believes that the public administration should not be separate from the political forces within the government. Now, having this approach, Rosenblum adds another third approach, and this is the legal approach. The legal approach means that the administration, the public administration, must again conform with the law of the country or the legal system in practice. That means the statutes or the acts of parliament, the constitution, the international law, and all those laws that have been ratified by the Republic of Kenya, the case law, that is the common law as practiced, and all those laws that are recognized within the Republic of Kenya as hailing from the nations forming the Commonwealth. I agree with this kind of approach and the theory. On the other side of Professor Paul Craig, who gives what I would call now the legal aspect of the public administration and looks at what he refers to the breach to statutory duty, the breach to common law duty, and also the breach of the Constitution. By sticking to the approach given by the breach, he sticks to the most quoted principle of the duty of care. The duty of care principle in the common law system refers to the fact that the action, the administrative action, should not cause any material, any mental, or any type of harm to whoever seeks the civil service from the public administration. If such behavior causes some harms, causes some damages that can be quantified, then one is allowed to petition the court and file the complaint in the court of law in order to seek justice, to seek remedy through the court. This is likened by tort offenses and misfeasances, and in this case the tortfeasor is subjected to legal liability. And in many cases, there are so many cases that complainants or plaintiffs have been very successful in seeking justice and remedy in the court of law within the United Kingdom legal system. This is a good approach, and it is the approach that would again compel any administrator to behave in line with the law and to provide the service as required and as expected by the Bill of Rights. Now, going back to Rosenblum's political approach, we find that some systems prefer that politics must not be separated from the public administration. The idea is basically based on the fact that at the end of the day, the politicians will be the final decision when it comes to the lawmaking. Fine, even passing of the budget of the government. And again, facilitating certain processes. So the public administration is seen to be effective when it works closer and in tandem and in a comprehensive manner with the legislative body. However, this as well can be a problem. This argumentation that politics should not be separate from the public administration can bring up what we would call now the corruption in the public administration. How about if the same politicians, both in government and those outside the government, collude and come together to canvass some administrative malpractices? It has happened. It can happen. It can be repeated in many other jurisdictions. We still believe and agree that to some extent the separation would be necessary. It would be necessary in the sense that the administrator should stick to the profession of his duty and abide by the law. That means the legal liability can be imposed upon any administrator that seems to breach the law. Another hypothesis is that if the same politicians are the ones to have the final word on the administrator in terms of appointments, in terms of canvassing the person from facing the wrath of law and justice, then the politician becomes the boss of the administrator. And the administrator in this situation shall tend to behave according to the wishes of the boss. It is just as simple as that. Now, in this case, I tend to prefer the separation between the politics and the public administration. We have seen in some Western civilizations that the government may be unstable. Politicians may have their squabbles, their disagreements, but this should not interfere with the public administration. Services to the civilians must be carried out as expected. Offices must operate as normal, even if the government changes. Politics, especially party politics, should not interfere with who is in office of the public administration. And if it does, then that will mean that whenever the government changes, the public administration will also behave in a different way. Now, what is clear, especially in the Kenyan system, from the 2010 constitution, we find that there are so many agencies that have been put by the constitution to oversee the public administration, namely the Auditor General. That is just one of the many examples that I can give you. There is Budget Controller, which is constitutional, and they are independent offices. And also the independence and separation of powers is well defined within the Constitution in a manner that the legislature should not be seen to be interfering with the independence and impartiality of the judiciary. The executive should not be seen to be interfering with the independence and impartiality of the judiciary, and vice versa. So having different institutions and bodies in place to create what we'd call now check and balances, or what we'd call now like the vetting bodies, vetting authorities, that would again ensure that the public administration, the implementing authorities or policies like law enforcement authorities should comply with the law. Such agencies adopt international standards. They adopt certain principles. They adopt things like ISO policies in the service delivery to ensure that the people or the civilians enjoy quality, standard-based, objective, and professional services from the administrators. So the public officers, state officers, are subjected to periodical evaluations, periodical inspections, in a manner that it keeps check and balances on different administrative departments of the government. And this is coming up as good news. It is very informative that there is in between the politics and public administration, in that politics should not be fully in charge of the public administration to an extent of dictating it or commanding it to behave or to do things that may not be correct. On the other side, full separation or separation between the public administration and the politics of the day can as well amount to some serious issues and problems. Why? Because we find that in that matter, the public administration can be too technical, very strict, and severe when it comes to offering civil services. Now, that flexibility must be anchored on this third authority that oversees or oversights the public administration and takes the matter seriously to an extent of subjecting the administrator to legal liability. And in that matter, administrator that breaches the statute, breaches the constitution, breaches administrative policies and decisions can be subjected to regular court process, and if found guilty, obviously the consequence will be the conviction or maybe the compensation award. So in that matter, there is a kind of regulatory system that makes sure that there is not too much separation and there is not too much, let us say, embedment between politics and the public administration. So by doing all this together, we find that the two theories can help us to merge the two into a system such like that one of Kenya. And I advise you to keep on reading, please, and refer to published articles and make sure that you get more information as much as possible. I believe that these video snapshots and short lectures help you to understand something on the administrative knowledge at the School of Law. I really expect our audience and viewers to be active, to be asking us questions. We'll be handling each and every question as they come so that we have that kind of interactive lecture in a manner that you interact with me. Thank you so much. I'm Peter Onyango. Once again, I remind you to keep on encouraging us. We may not be perfect. You may be better than what we are doing here. You may have more knowledge, but all the same, this is a drop in the ocean. Thanks so much and welcome for the next series. Thank you.